Hello, everybody. Today we are going to be reacting to a clip where the judge in the YSL Young Thug trial does sentence Young Thug's lawyer to 20 days in jail for standing up for his client. It's very strange. Before we get into the clip, just a really quick recap into what's actually going on in the case as far as this particular aspect is concerned. Now, this is a very complex case, and it has been going on for over a year. There's more than 20 defendants, and they're all being charged under the Georgia RICO statute. And the allegations are extreme. They are being accused, this group of alleged criminal organization, whatever, they are being accused of robbery, theft, carjacking, and even murder. Now, one of the star witnesses for the prosecution is a guy by the street name of Lil Woody. His real name is something Copeland, but Lil Woody is a character to say the least. Now, importantly, Lil Woody was guaranteed basically immunity if he were to testify against Young Thug and the YSL alleged ring. So that's very important because basically he got a plea deal to be a snitch. Now, on Friday, June 7th, Lil Woody was sworn in to begin his testimony against Young Thug, presumably. But coming as, I guess, a surprise to people, he went ahead and played the fifth, meaning he invoked his Fifth Amendment right to not testify against himself, which is your constitutional right to do. And since Lil Woody had been granted immunity, kind of entered into this deal already beforehand, the judge wasn't having any of this Fifth Amendment stuff and sent Lil Woody to jail over the weekend, that weekend of the June 7th. And that's where things start to get a little sticky because whenever court went back in on Monday, the judge had a meeting with Lil Woody and the prosecution, which is again headed by Fannie Willis's office, and he did not, meaning the judge did not inform the defense's lawyers. This is a huge deal because it's such a critical stage in the trial, and of course, Young Thug and anybody accused of a crime does have certain constitutional protections. So when court began that day, Brian Steele had somehow found out about this private secret meeting, which I don't even think was actually allowed, and he stood up and confronted the judge about it. Well, the judge, feeling busted and caught, went ahead and attacked Young Thug's lawyer and said, "How did you find out? How did you find out?" And Young Thug's lawyer's like, "I'm not telling you that because I have a duty not to interfere with how I found stuff out with the attorney-client privilege and all that." And the judge was like, "I'm gonna put you in jail. I'm gonna put you in jail." And the guy was like, "Okay, I guess if you must, but I'm still not telling you something just because you're threatening me." Well, the judge did hold Brian Steele in contempt of court and, like I said, eventually sentenced him to jail. But now that the lawyer is being accused of stuff criminally, right? Like there were allegations of maybe eavesdropping, criminal contempt, direct criminal contempt in court is a crime. And so he gets lawyers now. And so now Brian Steele's lawyers, the lawyer for the lawyer, they're about to argue this judge down. Let's see what they have to say. Oh, real quick. This is not legal advice. I'm not licensed to represent you. I'm not your lawyer. If you find yourself in need of legal advice, please go contact a lawyer licensed to practice law in your jurisdiction, which is not me. Also, everybody is innocent until proven guilty, should be presumed innocent until proven guilty. But if any of these people did any of the stuff they're accused of, then they should absolutely be held accountable. I'm not saying anything one way or another over if somebody's guilty or innocent. I'm just talking about this procedure with the judge and the lawyer and, in my opinion, tyranny and corruption.
Judge, just for the record, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
No, and with criminal contempt, I told him what the contempt was, and that was he refused to order the court, if counsel, as you know, if the court orders you to do something and you don't.
What I will say is, this man right here had a whole different attitude earlier in the day. Now, we did make a video already. I already made a video about the earlier in the day. Y'all should go watch that one. But whenever he was talking to Brian Steele, he had a whole lot of attitude. He had a whole lot of bluster. Now that he's talking to this lady and she's a complete and total bad ass, she's a boss. I would not want to go up against this lady in court because she's smart and she's usually right. She finds the corruption. She finds it. Oh, yes, she does. She has a track record of it. So she's kind of like what you would call in the legal world a bulldog. And you can really tell that this judge knows what he's dealing with. He's stuttering, he's sputtering, he's stumbling. He wasn't talking like that earlier. "I'll give you 5 more minutes before I hold you in contempt." He wasn't. He ain't talking like that now. He got to take 5. He gets so flustered.
I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was.
Acting like it's just so, oh, you know what this is reminding me of? The meeting I had with Larry Daradani, where they were trying to make me do some effed up stuff, some messed up stuff, and then they were saying, "But we asked nicely. I asked you nicely." If this judge was asking nicely to go run out in the middle of Fifth Avenue and gun somebody down, Would that be appropriate? No. Just because a judge asked you, please, to do something doesn't mean you have to do it. And that's what's the problem with these judges. They get in their own heads. They get in there. Everybody's calling them your honor and honorable. You ain't nothing honorable about this. This is tyranny. And you know what's really disgusting? This man was in the military. This man served in the military. He should know over anybody else that what's really sacrosanct isn't his ability to have a secret private meeting. No. What's really sacrosanct is due process, freedom of speech, the ability for people to talk to each other about stuff. That's what he should know. Disgraceful.
Because he's got too much detail of this particular alleged conversation for the court to be concerned about. So,
and Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And
no, criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding, and so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you're a witness to the proceeding.
Show me, but I just want to know.
Ooh, pause. Okay, y'all. She's saying, oh, okay, direct criminal contempt. That's what you said? Okay, cool, cute. That means you're a witness because you were party to the conversation, which is at issue here. And so because of that, you, Your Honor, cannot be on this case anymore. Goodbye. Recuse yourself. So really, honestly, truly brilliant. She is a smart lady. She's a smart lawyer, and she's also right. If someone is being accused of a crime, such as this lawyer is being accused of a crime, direct criminal contempt, then all their due process rights kick in. Fifth Amendment, Sixth Amendment, Fourth Amendment, search and seizure, right to remain silent, right to an attorney, right to a fair trial, a speedy trial, a hearing, a jury, all of that stuff. She's basically saying, all right, well, if you are the one who is accusing him of this direct criminal contempt, which the judge is, and he already charged him with it seems like, then you can't be also the judge that's the one that's going to sentence him because you're a witness to the thing. It's basically like literally Lord Cornbury crap. Like, oh, you don't talk about me. Don't get all up in my business, which isn't his business to begin with. It's the people's business. Because then I'm going to put you in jail. It's corruption. This lawyer is saying, Your Honor, okay, fine. But somebody else has to sentence him. You can't be the one to sentence him. That is a due process right. The judge is stupid and also, in my opinion, corrupt. And so he doesn't go with that. But she's very smart.
Told him this. That's all. I'm not asking him to release or.
All I want to know is who told him. All I want is someone to snitch so I can do some more corruption on that lawyer instead of Brian Steele. And Brian's like, no.
Any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Ms. Merton, and not answer a question of the court and not be found held in contempt?
If it's a question the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is
not. It's a question the court is permitted to ask, yes. But it is not a question, in my opinion, the court is permitted to hold someone in contempt for not answering. It's not, see, the judge is stupid. He's like conflating things that are not actually analogous. When I ask you a question, don't you think you have to answer it? Yeah, but like not any and every question. And that's really what's wrong with these judges.
First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You were a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them, by nature.
Okay.
Yes.
You have to be involved. Therefore, you have to be a witness.
Period.
So you are a witness. You cannot also.
But you got the information. But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I'm
not even sure that's even true. I'm actually not even sure that's true. I don't know that it's improper methodology for someone to tell the defense counsel that there was a meeting. I don't know. Somebody with more knowledge comment below. But I think the judge just says whatever he thinks will help him out. The judge could have signed some type of privacy motion, but somebody would have had to present a motion and it would have needed to go to the defense counsel. Even if the judge did sign some type of confidentiality or a gag order or something, there's just no way you could be doing all this crap behind the scenes whenever the person who is accused, it's just a fundamental tenet of our legal system that the accused person have access to all of the information in the case that everybody else has access to. There are absolutely sometimes exceptions here and there, but this doesn't seem like one.
One of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations.
So?
And that would not be permissible.
Why?
Judge, let's just
Under
back up
what?
for a second. He makes a motion because he has reason to believe that there were ex parte communications made.
There were.
The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned
I
it.
think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court
Right.
believes.
The judge
And a
can't
hearing
just
where
say, oh, I want him to tell me something and I felt like it. The judge has to give some type of rule violation. He's like, well, you wouldn't just come into court and not answer a question, would you? Okay, but what's the rule? Because Brian Steele is saying, Your Honor, under attorney ethics rule number 1.6, I am not going to disclose information that I acquired in the process of representing my client. And the judge is like, no, but I want you to tell me, so you're in contempt. No, what's the violation? What's exactly the criminal code he violated? Just because the judge felt like it? Certainly that can't be what our justice system is running off of, because we have way bigger problems than I even imagined.
I can call you as a witness. You can testify. You are necessarily a witness.
Buddy.
You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
Yep.
I'll let an appellate court decide that.
I bet you will.
But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that.
That's
this evening.
extortion.
He can do it. He can do it right now. He can do it at any point.
This man wanting to accuse other people of extortion is saying he's getting a contempt charge and he can purge the contempt charge just as soon as he does what I want him to do. That's extortion. You're going to go to jail unless you do the unlawful thing that I'm telling you to do, or unless you do the thing that I'm unlawfully ordering you to do. In my opinion, I don't know. We are going to let the appellate court decide, and I guess whatever they decide is what's going to be.
Time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant a bond. At this point, grant him a bond on that issue.
And you don't get a supersedeas bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in his contempt is as long as he when he tells me what the basis of the conversation was. I didn't ask what, but he tells me that, then I can certainly he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
That's civil.
And that's
So the stupid judge, this idiot, he don't even know. This idiot don't even know how the two different contempts work. And these lawyers probably making $15,000 an hour or something, having to stand here and explain it to him like he's in a first-year law school class. There's a difference between direct criminal contempt and civil contempt. There's certain protections that come in on each of them. Civil contempt is whenever you're actively doing something in a civil case that is putting the trial at risk, is putting someone at risk, and it's an active ongoing issue that you just have to be detained. This direct criminal contempt is a jail sentence, which would allow for a bond in my understanding. Again, I'm not an expert. Somebody, if you're an expert, tell me if I'm wrong. But from what I understand, it's if you have a criminal contempt, then the bond can apply. A civil is no, you have to cure the thing you're doing or else serve the full sentence. And I think they can hold you indefinitely, which I think is insane for civil. The judge don't understand. I understand it better than him, and I ain't a judge. That's sad.
Civil contempts impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or
I think that's what this judge wants. This judge, everybody, and that's why I had that law license for I think maybe 1 year, and I said, "Oh, ew, gross! Take this back," because literally the whole time you're practicing, you're looking over your shoulder like, "Oh no, is some tyrant judge going to act a damn fool and interfere with my ability to make money?" Because look, that's what he's doing. You think this judge gives two rats asses if Brian Steele loses his license? Nope. And he holds the keys to make sure that could happen. Huh.
And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that
okay,
takes
that's
away
fair.
the
I mean, I'm not doing this. Like, I think the judge is realizing how much of a circus this is about to turn into. And he's like, I'm not doing this. But instead of saying, you know what? Okay, fine, don't tell me. No contempt. Get out of my face. Let's carry on with this trial. He digs his heels in because of his ego. And I'm not doing this. And so instead of just saying, all right, fine, no more contempt charge, whatever. He's like, I'm not doing this, and Brian Steele's going to jail, and let the appeals court decide, and all this tyrannical dictatorship.
point of criminal contempt, and that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the that's contested.
Brian Steele is saying that the judge did order him to do something unethical, strictly speaking, because of the attorney ethics rules that he believes he would be violating by telling this information.
What the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who.
Stupid.
The person.
Wrong.
Because okay, I'm sorry.
No.
Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about this a second, okay?
That means let me go ask my clerk, who's probably smarter than me.
Thank you for your patience, counsels. The court's had an opportunity to reflect, and Mr. Steele, if I could ask you to take the podium, please, as well. Stand next to your attorneys, Mr. Schuster, as well. All right, counsels, I've made a clarification to the order of contempt. Mr. Steele, I am going to still hold you in summary criminal contempt pursuant to OCJ 15-1-3, subpart 3.
Oh, so he finally came back with a code.
Today, I'm going to order that you be taken into custody and incarcerated in the Fulton County Jail for no more than 20 days for this contempt.
And this is the stupid thing. he's now like, this trial hasn't lasted long enough. I think a lot of the judge's issue here is that the trial is just taking forever. This is one of the longest trials I ever heard of. I mean, the trial itself, I think, has been going on for a year. There's been circus clowns and carnivals as far as the eye could see. So on the one hand, I can understand why the judge is a little bit frustrated and just ready to get this thing going. But then on the other hand, his actions are, okay, well, I'm going to put the lead attorney on the case, on the defense, in jail for 20 days. Like, okay, it kind of takes out the legs of your argument that you're trying to hurry this thing along if you're going to put the lead defense attorney in jail for 20 days for what? Because he won't answer your dumb question, your stupid question that who gives a shit how he found out? Now he's going to jail. Imagine this is where we live. An attorney is going to jail because he found out that a judge had an improper meeting. And that same judge is putting him in jail.
Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m.
This judge should be put in jail. This is ridiculous. Again, if Young Thug did what he's being accused of doing, he should be held accountable. But he should have a fair trial. Because if the Young Thugs of the world don't have a fair trial, what's to stop you from not having a fair trial?
You may take whatever steps you and your counsel deem appropriate after that. Okay?
Can I ask a question?
I hate it here.
I'm going to file a notice of appeal, but if for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, if that comes to pass, you have my support. I will talk with our sheriff and we may be able to make that work. Okay? If that
We may.
occur, okay?
That's funny. The guy was like, okay, fine. If I got to go to jail every weekend, then put me in jail with my client and let us be in the same cell. So apparently, just to kind of sum up what had happened, the judge did sentence him, but something, one thing, other thing, procedure. The guy, Brian Steele, he does not have to actually serve any time in jail until it is decided by the appeals court. It's kind of like going to be considered on appeal, whether that was even something that the judge was even allowed to do, all the, procedural intricacies, logistics. And so the jail sentence itself has been stayed. But I do believe that the contempt charge and all of that is still in play. So we'll see how it goes. I mean, I think I pretty much said what I think about the whole thing now. As I went, I think it's ridiculous, but I do think that the judge's frustration of how long the trial is taking and, just trying to hurry up and get the people to testify and stuff at this point, I understand that. But I don't think he's allowed to do some of the things that he's been doing. I'll put it that way. That's all I really had for today's video. Make sure to check out the other video that I did make about this. And I will be reading, I don't know which one's going to come out first, I don't know. But I will be reading a document that Brian Steele did file to basically ask the judge to recuse himself from the case for being biased and stuff like that. So I'll get into that in another video, next video maybe. And yeah, that's all I really have for today. In the meantime, facts ain't defamation and neither is responding to a video. Love you, mean it, okay, bye. Welcome into my world. You're playing my game. Thought that you could come up and they're fitting off of my name. Talking out the side of your neck like you're insane. Cortisol levels to the roof. Inflame. Kids these days so shameless. Selling out real friends for a paycheck. Mama didn't teach them no home training. Wanna be me so bad, but they failing. Step to the plate though. I'll take a challenger. I ain't scared of no low life scavenger. I should warn you though, if you haven't heard, I ain't no Colleen ukulele ballager. Shots been fired. Run and tell that. Say it to my face though. Now behind my back. Won't be long till you share it in the group chat. And when I call you up, you're gonna backtrack. And you should've kept my name out your mouth.